Hello. Today we're going to talk about whether a text message or an email can create a valid purchase contract. NAR recently reported on 2 court decisions in the state of Massachusetts that looked at the issue of whether an email or a text message can create a valid purchase contract. And this is a question we get fairly regularly when we're teaching contracts, and so I wanted to take this opportunity to look at some of the many issues that this question raises. Under the statute of frauds, all contracts for the sale of real property must be in writing to be enforceable. That writing must contain all the essential terms of the agreement. So the first question is whether an email or a text even constitutes such a writing for the purposes of the statute of frauds. Both Massachusetts courts found that they did, meaning that in theory, a contract can be formed by email or text message. Now, a Massachusetts court decision is not binding in Virginia, but it is definitely something we need to be aware of. If a Virginia court were to find the same, that an email or text message could form a contract, then under the statute of frauds, that message must also contain the essential terms of the agreement to be enforceable. This is a real gray area. What are the essential terms of the agreement? Well, this has not been specifically determined, although courts have referenced price or closing date, title, deposit, financing, and other contingencies. It's unclear which terms a court would require as the essential terms necessary to form an enforceable contract, and it's unlikely that all these terms would be included in a text message. There's also no guarantee that courts would find the same terms essential in different contexts. However, even if a court found that all of the essential terms of the contract were included in the message, there's still another question. The text or email messages are presumably between 2 agents, not the actual buyer and seller. So does the agent even have the authority to bind his or her client? Well, in the VAR exclusive authorization to sell, Form 400, there is specific language that addresses this question. So the form states, this agreement does not confer upon broker the power or authority to either make or accept an offer or counteroffer to sell the property. The property may be sold only by a written agreement executed by the owner or by an attorney in fact for the owner under a written power of attorney. Broker's authority hereunder shall be limited to marketing the property for sale and such activities as are necessary or incidental thereto. So if you find yourself in a situation where you are questioning whether a contract has been formed and whether your client is now bound by that contract, please speak to an attorney. The takeaway here is that accepting an offer or a counteroffer by email or text is very risky for both you and your client. It's always a best risk management practice and likely in the best interest of your client to not rely on texts and emails going back and forth to bind the buyer and the seller, but to get a fully executed written contract as soon as possible. Thank you.